Tallahassee, the capital city of Florida, while one of the northernmost cities in the state, it's still known for its warm and humid weather in the winter months, like on December 10th in 2019, when the highs of the day were well above 70 degrees Fahrenheit. On that typical Florida day, 2 small children, aged 1 and 3, were exposed to inhumanely high temperatures inside the filthy, cramped room of a mobile home where their biological mother was living with an illegal immigrant, who was not their biological father, but took on responsibility of a parent. The so-called father went to check on the kids and found them unresponsive and overheated in the trailer. Here at Deep Dive True Crime, we have trials that you will not find anywhere else. This one in particular is going to be quite intense. It involves Brittany and Pedro, and the death of one of Brittany's 2 children, 1-year-old Alex. This is the trial in the case of State of Florida versus Pedro Agustin Ramirez Alvarado. If you are a regular to our channel, then it is likely that you already know about this case. Perhaps you watched The Brittany Show, the full interrogation of Brittany Delgado. If you did, then you saw photos of the filthy conditions of the mobile home where Brittany and Pedro lived together as a couple, raising Brittany's children, 2 boys aged 1 and 3. And if you watched her interrogation, you likely recall that Brittany Delgado, who is in her mid-20s when the events that led to Pedro's trial happened, had 3 additional children, who she had to give up to the state of Virginia, for a total of 5 children. You may also recall that Florida child protection investigators were already looking into how Brittany was raising her 2 subsequent children after she moved to Florida to live with Pedro, and were ready to offer help. But if you watched Brittany's show, her interrogation, you are more likely to remember the horrific fate of Brittany's 2 little boys. The smaller one, Alex, died at the age of just 1 year old. The oldest one, Julio, also referred to as Casper, survived. Both of them had been left alone in a hot room of the mobile home, with the heater on, while Brittany was busy on the phone with an insurance company, and Pedro was doing something else. You may also remember all of Brittany's excuses, and all the blame she tried to put on Julio, the 3-year-old, and on Pedro. Watching this trial will give us a greater insight, hopefully, about what happened that fateful day, and why a precious 1-year-old child died in such a horrific way. And watching this trial, you will also get to see Brittany's latest show, her performance on the witness stand. So, here we go. Let's get started on the trial. Justice for baby Alex. Here we go! In this video, you will get to see everything from the closing arguments to the verdict.
We ready for the jury now?
Yes, sir.
Bring them on. Seated, please. I told you sometimes we give new meaning to the term promptly. I apologize for the delay. If you have to be upset with somebody, the buck stops with me, not the attorneys. If any of you haven't discussed the case among yourselves, no one's discussing it present. Members of the jury, I thank you for your attention during this trial. I ask that you please pay attention to the instructions I am about to give you. Pedro A. Ramirez Alvarado, the defendant in this case, has been accused of the crimes of aggravated manslaughter of a child as to YD, and aggravated child neglect causing great bodily harm as to JM. I'm going to give you a copy of these instructions to take with you to the jury room. To prove the crime of aggravated manslaughter, the state must prove the following three elements beyond a reasonable doubt. Number one, YD is dead. Number two, the death of YD was caused by the culpable negligence of Pedro A. Ramirez Alvarado. And three, YD was at the time a child, and YD's death was caused by the neglect of Pedro A. Ramirez Alvarado, a caregiver for YD. Every person has a duty to act reasonably toward others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of aggravated manslaughter by causing a death because of a mere negligent act. But culpable negligence is more than a failure to use ordinary care towards others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing a reckless disregard of human life or of the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise the presumption of a conscious indifference to consequences, or which shows wantonness or recklessness or a gross careless disregard for the safety and welfare of the public, or such an indifference to the rights of others as is equivalent to an intentional violation of such rights. The negligent act or omission must have been committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily harm. The defendant cannot be guilty of aggravated manslaughter if the killing was either justifiable or excusable. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. The killing of a human being is excusable and therefore lawful under one of the following three circumstances. Number one, when the killing is committed by accident and misfortune in doing a lawful act by lawful means with the usual ordinary caution and without any unlawful intent. Or, two, when the killing occurs by accident and misfortune in the heat of passion upon a sudden and sufficient provocation. Or three, when the killing is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. A dangerous weapon is any object that will likely cause death or great bodily harm if used in the ordinary and usual manner contemplated by its design or construction. An object not designed to inflict bodily harm may nonetheless be a dangerous weapon if it was used in a manner likely to cause death or great bodily harm. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. I have previously instructed you on the circumstances that must be proved before Pedro A. Ramirez Alvarado may be found guilty of aggravated manslaughter of a child or any lesser included crime. Child means any person under the age of 18. Caregiver means a parent, adult, household member, or other person responsible for a child's welfare. Neglect of a child means a caregiver's failure or omission to provide a child with the care, supervision, and services necessary to maintain a child's physical and mental health, including but not limited to food, nutrition, clothing, shelter, supervision, medicine, and medical services that a prudent person would consider essential for the well-being of a child, or a caregiver's failure to make reasonable effort to protect a child from abuse, neglect, or exploitation by another person. Exploitation by another person, excuse me. Neglect may be based on repeated conduct or on a single incident or omission by a caregiver that results in or could reasonably be expected to result in serious physical or substantial risk of death to the child. Now, in considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which he is accused, there may be evidence that he committed other acts that would constitute a lesser included crime. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crimes indicated in the definition of aggravated manslaughter of a child are manslaughter, aggravated neglect of a child, and culpable negligence. To prove the crime of manslaughter, the state must prove the following two elements beyond a reasonable doubt. Number one, YD is dead. Number two, the death of YD was caused by the culpable negligence of Pedro A. Ramirez Alvarado. Every person has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justified or excusable, as I have previously instructed you. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. I will now define culpable negligence for you. As I have said, every person has a duty to act reasonably towards others. If there's a violation of that duty without any conscious intention to harm, the violation is negligence. But culpable negligence is more than a failure to use ordinary care towards others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard of human life or of the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to consequences, or which shows wantonness or recklessness or a grossly careless regard for the safety and welfare of the public, or such an indifference to the rights of others as is equivalent to an intentional violation of such rights. The negligent act or omission must have been committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily harm. Now, to prove the crime of neglect of a child causing great bodily harm, permanent disability, permanent disfigurement, the state must prove the following 4 elements beyond a reasonable doubt. Number 1, Pedro A. Ramirez Alvarado willfully or by culpable negligence failed to or omitted to provide YD with the care, supervision, and services necessary to maintain YD's physical or mental health, or failed to make a reasonable effort to protect YD from abuse, neglect, or exploitation by another person. 2, in doing so, Pedro A. Ramirez Alvarado caused great bodily harm, permanent disability, or permanent disfigurement to YD. 3, Pedro A. Ramirez Alvarado was a caregiver for YD. And 4, YD was under the age of 18. Neglect of a child may be based on repeated conduct or on a single incident or omission that resulted in, or reasonably could have been expected to result in, serious physical or mental injury or a substantial risk of death to a child. Caregiver means a parent, adult household member, or other person responsible for a child's welfare. I will now once again define what is meant by the term culpable negligence. Each of us has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, the violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. For negligence to be called culpable negligence, it must be gross and flagrant. The negligence must be committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily harm. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate, and as such does not include mere bruises. Now, to prove the crime of culpable negligence, the state must prove the following 2 elements beyond a reasonable doubt. Number 1, Pedro A. Ramirez Alvarado exposed YD to a personal injury. He did so through culpable negligence. Actual injury is not required. Once again, I will define culpable negligence for you. Each of us has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, the violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard for human life or for the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of conscious indifference to consequences, or which shows wantonness or recklessness or a grossly careless disregard for the safety and welfare of the public and shows such an indifference to the rights of others as is equivalent to an intentional violation of such rights. Now as to count 2, to prove the crime of neglect of a child causing great bodily harm, permanent disability, permanent disfigurement, the state must prove the following 4 elements beyond a reasonable doubt. Number 1, Pedro A. Ramirez Alvarado willfully or by culpable negligence failed or omitted to provide J.M. with the care, supervision, or services necessary to maintain J.M.'s physical or mental health, or failed to make a reasonable effort to protect J.M. from abuse, neglect, or exploitation by another person. In doing so, Pedro A. Ramirez Alvarado caused great bodily harm, permanent disability, or permanent disfigurement to J.M. 3, Pedro A. Ramirez Alvarado was a caregiver for J.M. And 4, J.M. was under the age of 18. You're going to get tired of hearing some of these, but I'm required to give them. Okay. Once again, neglect of a child may be based on repeated conduct or on a single incident or omission that resulted in, or reasonably could have been expected to result in, serious physical or mental injury or a substantial risk of death to a child. Once again, a caregiver means a parent, adult household member, or other person responsible for a child's welfare. Once again, I will now define what is meant by the term culpable negligence. Each of us has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, the violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. For negligence to be called culpable negligence, it must be gross and flagrant. The negligence must be committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily harm. Once again, great bodily harm means great as distinguished from slight, trivial, minor, or moderate, and as such does not include mere bruises. Now, in considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which he is accused, there may be evidence that he committed other acts that would constitute a lesser included crime. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crimes indicated in the definition of aggravated child neglect causing great bodily harm are child neglect and culpable negligence. To prove the crime of neglect of a child, the state must prove the following 3 elements beyond a reasonable doubt. Number 1, Pedro A. Ramirez Alvarado willfully or by culpable negligence failed or omitted to provide J.M. with the care, supervision, and services necessary to maintain J.M.'s physical and or mental health, or failed to make a reasonable effort to protect J.M. from the abuse, neglect, or exploitation by another person. 2. Pedro A. Ramirez Alvarado was a caregiver for J.M. And 3. J.M. was under the age of 18. Once again, neglect of a child may be based on repeated conduct or on a single incident or omission that resulted in, or reasonably could have been expected to result in, serious physical or mental injury or a substantial risk of death to a child. Once again, caregiver means a parent, adult household member, or other person responsible for the child's welfare. And once again, I will now define what is meant by the term culpable negligence. Each of us has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. For negligence to be called culpable negligence, it must be gross and flagrant. The negligence must be committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily harm. Now, to prove the crime of culpable negligence as to J.M., the state must prove the following two elements beyond a reasonable doubt. Number one, Pedro A. Ramirez Alvarado exposed J.M. to personal injury, and 2, he did so through culpable negligence. Actual injury is not required. Once again, I will define culpable negligence for you. Each of us has a duty to act reasonably towards others. There's a violation of that duty without any conscious intention to harm. The violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard for human life or for the safety of persons exposed to the dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to consequences, or which shows wantonness or recklessness or a grossly careless disregard for the safety and welfare of the public, or shows an indifference to the rights of others and is equivalent to an intentional violation of such rights. Now, the defendant has entered a plea of not guilty. This means you must presume the defendant is innocent. This presumption states for the defendant as to each material allegation in the information through each stage of the trial, unless it's been overcome by the evidence, to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you're to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence, which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are, did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Does the witness's testimony agree with the other testimony and other evidence in the case? Has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves any more or less consideration than that of any other witness. Now, expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. Now, it is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or of the testimony of any witness. Now, the defendant in this case has become a witness. You should apply the same rules to consideration of his testimony that you apply to the testimony of other witnesses. Now, there are some general rules that apply to your discussions, and you must follow these rules in order to return a lawful verdict. You must follow the laws as set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. This case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits and evidence and these instructions. This case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is my job to determine a proper sentence if the defendant is found guilty. Whatever verdict you render must be unanimous, that is, each juror must agree to the same verdict. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. As I said before, deciding a verdict is exclusively your job. I cannot participate in that decision in any way. I ask that you please disregard anything I may have said or done that made you think I prefer one verdict over another. You may find the defendant guilty as charged or guilty of such lesser included offense. You may find the defendant guilty as charged or guilty of such lesser included crime as the evidence may justify, or not guilty. If you return a verdict of guilty, it should be for the highest offense on the verdict form for each count that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. The verdict must be unanimous, that is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. The verdict must be in writing, and for your convenience, the necessary forms of verdict have been prepared for you, and I will now attempt to read them to you. Count 1. We, the jury, find as follows as to count 1 of the information. Check only 1 as to this count. A. The defendant is guilty as charged of aggravated manslaughter of a child as to YD. If you find the defendant guilty of aggravated manslaughter of a child, you must then answer the following questions. Check only 1 box for each. Did the state prove beyond a reasonable doubt that the defendant was a caregiver for YD? There's a yes and no box to check for. Did the state prove beyond a reasonable doubt that YD was under the age of 18? Once again, it's a yes/no check off. Did the state prove beyond a reasonable doubt the death of YD was a result of the defendant's culpable negligence? Check off for yes or no. B. The defendant is guilty of the lesser included offense of manslaughter as to YD. If you find the defendant guilty of manslaughter, you must then answer the following questions. Did the state prove beyond a reasonable doubt that YD was under the age of 18? Once again, a yes/no check off. And C, the defendant is guilty of the lesser included offense of aggravated neglect of a child causing great bodily harm, permanent disability, or permanent disfigurement as to YD. If you find the defendant guilty of aggravated neglect of a child causing great bodily harm, permanent disability, or permanent disfigurement, you must then answer the following questions. Did the state prove beyond a reasonable doubt that YD suffered severe physical injury as a direct result of the crime? This is a yes, but on the next page is a no. Okay? Did the state prove beyond a reasonable doubt that YD suffered moderate physical injury as a direct result of the crime? Once again, just check off yes or no. D. The defendant is guilty of the lesser included offense of culpable negligence as to YD. And E. The defendant is not guilty. as to count 2. We, the jury, find as follows as to count 2 in the information, and you check only 1 as to this count. The defendant is guilty as charged of aggravated child neglect causing great bodily harm as to J.M. Below that, did the state prove beyond a reasonable doubt that J.M. suffered severe physical injury as a direct result of the crime? Once again, there's a yes/no box. Check. Did the state prove beyond a reasonable doubt that J.M. suffered moderate physical injury as a direct result of the crime? Once again, there's yes/no check off. B, the defendant is guilty of the lesser included offense of aggravated neglect of a child causing great bodily harm, permanent disability, or permanent disfigurement as to J.M. Below that, did the state prove beyond a reasonable doubt that J.M. suffered severe physical injury as a direct result of the crime? So yes/no check. Did the state prove beyond a reasonable doubt that J.M. suffered moderate physical injury as a direct result of the crime? Once again, yes/no check off. C, the defendant is guilty of the lesser included offense of culpable negligence as to J.M. And D, the defendant is not guilty. So say we all this blank day of May 2004. It's a line for the foreperson's signature. Now, a separate crime has been charged in each count of the information, and although they have been tried together, each crime and the evidence applicable to it must be considered separately and a separate verdict returned as to each. The finding of guilty or not guilty as to one crime does not affect your verdict as to the other crime charged. Now, both the state and the defendant have now rested their case. The attorneys will now present their final arguments. Please remember that what the attorneys say is not evidence or your instruction on the law. However, do listen closely to their arguments. They're intended to aid you in understanding the case. Now, each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defense has spoken. You ready to proceed, counsel?
Yes, Your Honor. May I proceed? May I adjust the podium?
Absolutely.
Good afternoon, ladies and gentlemen. I promise this is the last time you'll have to hear me thank you, but I do want to thank you for your time and your attention and your patience in this matter. You only have to listen to me talk at you for a little bit longer, and then you can get back into the deliberation room and start doing your work on this case. I do get to do an opening and then a rebuttal argument because I have the burden, so I get the last word. I want to go through the jury instructions and the verdict form a little bit with you. A copy of them will go back with you into the jury room. I'm not going to reread them all because obviously we all just sat here and listened to the judge read them to you, but I do kind of want to show them to you and go through them a little bit because I think they're important. Okay, so this is the first page of the jury instructions, and to kind of keep you guys clear, I'm sure you've been paying very close attention, but count 1, which is the aggravated manslaughter of a child, that relates to, and we have their initials in the jury instructions because they're children, that relates to Jonathan. So the deceased child relates to count 1. Count 2 relates to Julio. So the surviving child is for count 2. Count 1 is solely for Jonathan, and count 2 is solely for Julio. So each one of them have their own separate counts. So when we're talking about count 1, we're only talking about Jonathan. Obviously, the facts of what happened overlap for both of them because the same incident caused the death of one and the injury to the other. So for Jonathan, for the aggravated manslaughter of a child in count 1, remember in jury selection how we talked about elements and compared them to baking a cake? These are what I had to prove to you. So these 3 elements. Number 1, that Jonathan is dead. I would hope that there is no dispute about that element. I think it's pretty clear that he is deceased. If you forget and really want to take a look at the pictures again, the pictures of his autopsy are in evidence. Number 2, that the death was caused by the culpable negligence of this defendant, and that number 3, at the time Jonathan was a child. Again, I really hope that that is not in dispute. He was a year old at the time. You've heard no other evidence, no contradictory evidence, and I think clearly by looking at the pictures you can tell he was a child. And that his death was caused by the neglect of this defendant, who was a caregiver for that child. Hopefully that's not too small or blurry for y'all to see. I'm just trying to help you follow along with my argument. But again, you'll get to take these back with you to the jury room. I just want to briefly touch on justifiable and excusable homicide. I think you all should pretty quickly be able to skip right past these. Justifiable homicide is if someone is trying to commit a felony against you. Neither one of these children were trying to commit any crime. They were just being children. So that's not applicable. A lot of these instructions, number 1, probably seem very confusing, very repetitive, and like some of them don't apply. We're required by the law to give you a lot of these instructions. Unfortunately, even ones that don't really apply, like this one. Same for excusable homicide. Each one of those scenarios are not applicable in this case. They all relate to accidents that were from some sort of misfortune. So the number 1, committed by accident and misfortune in doing any lawful act by lawful means with a usual and ordinary caution. Again, that does not apply in this case whatsoever. Neither does number 2. Heat of passion upon sufficient provocation. Just a reminder, we're talking about children here. Number 3, which is on the next page. When the killing is a result from sudden combat. Again, read through all of these again if you feel like you need to. However, I think it's very clear from the circumstances that you can skip past justifiable and excusable homicide because they just simply do not apply. I'm going to come back to the definitions on the bottom of this page, which are caregiver and neglect. So we will come back to those because they're obviously important. There are multiple lesser included crimes in count 1. The lesser included crimes are manslaughter, aggravated neglect of a child, and culpable negligence. Each of them are in order in the jury instructions. However, as to the manslaughter count, and again, talk about all of these and consider them if you think that they apply. However, my argument is that they don't, and you should skip over each of them, and I will explain why. Manslaughter only has 2 elements, and you can distinguish it from how he is charged in count 1 with aggravated manslaughter because it ignores the fact that this death was the result of neglect. So it completely removes that neglect element and it removes the caregiver element, both of which are very important in this case and both of which have been proven. So again, I think those are 2 very important things that we have met a higher burden and a higher standard by proving a higher crime, and this crime is not applicable. The aggravated child neglect, I think, is self-explanatory as to why it doesn't apply, because it completely ignores the fact that the child is dead. None of these elements say that the child is dead. They say that the child suffered great bodily harm, permanent disability, or permanent disfigurement. So again, required for us to give them to you, but does it really apply based on our facts? No. Same thing for culpable negligence. Just says that he was exposed to personal injury. It completely ignores the fact that he is dead and completely ignores the fact that his death is the direct result of this defendant's neglect. So, moving on to count 2. Again, count 2 relates to Julio. This is the crime as charged, aggravated child neglect causing great bodily harm. Required to prove to you 4 elements. And element 1 is an either or. So either he willfully or by culpable negligence failed or omitted to provide care, supervision, and services necessary to maintain Julio's physical and mental health, or failed to make a reasonable effort to protect him from that by another person. Obviously, I think the very clear other person meant by this element is Brittany Delgado. So you can find him guilty of this if you think either he did it or if he failed to protect this child from her neglect. I think it's very clear, again, from the evidence, and I'll go through all of this with you, that both of them neglected these children, but if for some reason you disagree with my analysis and think that it was solely Brittany Delgado, you can still find him guilty of this if you think he failed to protect them from her. That he caused great bodily harm, permanent disability, or permanent disfigurement to Julio. That video that I played of Julio from his foster mother is in evidence. It's on the disc. It's the only disc that I've entered into evidence. You can rewatch that if you want to. I know it's pretty hard to watch. And the photo of him currently is in evidence. I think it's very clear, the testimony that has come out about his functioning then versus now. Number 3, that he was a caregiver. We'll talk about that. And number 4, that Julio was under 18 years of age. Again, I would hope that that element is not in dispute. I have the same or similar arguments for the lessers on this count as well, but I'll go through each of them with you to explain why. So the first lesser is just simple neglect of a child. I think on the verdict form we actually made a typo, which I'll get to when we talk about the verdict form. So the second, the lesser included crime is just neglect. I think the glaring problem with this is obviously that it does not have the fact that this child suffered great bodily harm and permanent disability as a result of this crime. So I would submit to you that does not apply for that very specific reason. And same with the culpable negligence. Just like for Jonathan, it's the same thing. It ignores how serious this crime was and how much of an injury this child suffered as a result of this defendant's conduct. So I'll just show you the verdict form and then we'll talk about the evidence. This is what the verdict form looks like. So count 1 is in bold, black, and then you'll notice count 2 is also in bold, black. So they're separated. I know it's a lot of reading, it's a lot of words. That's how they're separated. And then for each count, the main crime versus the lessers are labeled by these letters. So A is guilty as charged. B down here is the first lesser. C is the second lesser. D is the third, and then E is not guilty. And same for count 2. As we call them, interrogatories, or the yes-no questions. So for each count, you check only one. A, from like guilty as charged down to not guilty. You only check one. Don't check like guilty as charged and guilty of the lesser. We have had people do that before because these forms are very confusing. So that's why I'm telling you. So only check one, but for the yes-no questions, we do need you to answer all of the questions for whatever crime you pick. Like if you pick A, that he is guilty as charged, you have to answer all the next questions that follow. So, and you check either yes or no for each one. So if you find A, that he's guilty as charged, you don't need to answer the yes or no questions under B and C. And same for count 2. Hopefully that helps a little. I know me, I'm a visual person. I like to see things. So anyway, let's get into how the state proved this to you beyond a reasonable doubt. Remember my opening statement, how I compared evidence to puzzle pieces, how one piece in and of itself may not be enough to show you the whole picture, to prove the case beyond a reasonable doubt. However, I think that the state has more than overcome their burden of beyond a reasonable doubt based on all the witnesses and the evidence that you have seen and heard. So what is the story that you heard? What is the picture that was painted and created in this puzzle of evidence that you received? You heard that the only people living in that trailer at 6054 Dome Level Road were Brittany Delgado, this defendant, and the 2 children. That you heard that the 911 call by Brittany Delgado was placed about 1:14 p.m. on December 10th, 2019. That when law enforcement arrived, that they had brought the children outside of the house, that the children were extremely sweaty, that they were very warm to the touch. Every person who touched those children noticed and mentioned how warm they were to the touch. They also said that based on their, medical training and experience, that the 1-year-old, Jonathan, was already dead when they got there. Remember what the EMTs and the firefighters told you about how his skin was modeling and his eyes were open, that they were cloudy, that they were dry. Those are things that happen after someone dies. He was already dead before they got there. And then Julio, he did die, and they were able to revive him. and remember how high their body temperatures were. Those children, what their body temperatures were. Jonathan's body temperature was 108 degrees. They took his rectal temperature, 108 degrees. And Julio was at 106.5. That is an insanely high temperature for anyone, let alone 2 infants. And the fact that Julio survived that is nothing short of a miracle, frankly. I mean, you saw the condition that he was in when he was brought to the hospital. He couldn't breathe on his own. He couldn't eat on his own. And he suffered severe neurological and brain damage that is permanent, that he has to live with for the rest of his life. You saw all the photos of the trailer, the photos of the children, autopsy photos, and you heard from quite a few different doctors. Dr. Flanagan, who did the autopsy and told you that Jonathan's cause of death was hyperthermia. Because of his body temperature, it was just not compatible with life. And the rest of his body was perfectly healthy for a child of his age, that there was no reason that he should have died. The only explanation for his death is that he cooked to death. It's as simple as that. Dr. Pena told you what would happen to a child, what a child would do. And honestly, I think that's common sense. You know, a lot of people, even people who don't have kids, know that when children are uncomfortable, what do? What's the first thing a kid does when they're uncomfortable, when they're mad, when they're angry, when they're hungry? Anything. What's the first thing they do? Cry. And these kids would have been crying. They would have been back in that room, and they would have been crying and screaming, hoping that their mom or this defendant, the only 2 people in the world who could have protected them, would have. And they didn't. That is not a large trailer, ladies and gentlemen. There is no way they did not hear those babies crying. There is no way.
Objection. Facts not in evidence as to crime.
Move on.
That, not reasonable, ladies and gentlemen. And what do we know from what Dr. Bouchon told us about how long they would have had to have been back there without supervision in order to even get to that point? The lowest time period he ever said was 45 minutes. And remember, that's not just like 45 minutes, whatever. That's 45 minutes if the room started out at the hottest possible temperature when they went into the room. If the room was over, I think, what did he say? The highest max temperature was 108 degrees. So if those kids went into that room, which again, let's use our common sense, why would 2 children that young go into a room that is that hot and that uncomfortable? Why would they do that? Let alone stay in there for 45 minutes, which would have had to have been required for them to reach those internal body temperatures. Or the alternative, because obviously, and like I told you in jury selection, I don't have to prove to you every possible fact that you may want to know. And you may want to know, how did those kids get back in that room? Did they put themselves in there? Did this defendant put them in there? Did Brittany Delgado put them in there? We'll never know, ladies and gentlemen. We will never know, because the 2 main witnesses to that, one is dead and the other can't communicate. So the 2 people who put those children in that room Who would know, who would really know, and who would tell you what really happened? Can't tell you. And Brittany Delgado and this defendant sure are not going to tell you. Because if they tell you that they put those children in that room on purpose and they locked them in there, that's first-degree murder. And they're not going to admit to that. No way. Now, are the circumstances of this crime extremely suspicious? Yeah, they are. Is it weird that the door locks from the outside? Yeah, it absolutely is. And is it even weirder that they both said, or at a minimum, Brittany Delgado said, that Julio could open and unlock doors. But yet, when he's trapped in this room, cooking to death, he can't get out? Why couldn't he get out if he can open doors? This room had a door just like all the other ones, except this door locked from the outside. And by the time law enforcement got there, remember, the kids were already outside of the house. That's weird. It's weird that these kids were even in this room to begin with, because remember what this room looks like, okay? Diaper on the floor. Trash. Is there anything in that room for a baby? Any toys? Any bed? Anything? Any reason that a child should be in that room? Let alone unsupervised. The amount of hazards in that room besides the space heater, trash, cords, plastic, they could have choked to death. They could have eaten any of that stuff, and nobody would know because they were in there alone. So who knows if they were placed into the room when it was already 108 degrees. Maybe they were. And then they didn't have to suffer as long, because then it would have only taken 45 minutes for Jonathan to cook to death and Julio to almost. The other explanation is that they were put into the room, or they walked into the room and somehow locked themselves in and turned the heater on all by themselves, a 1 and a 3-year-old. And then over the course of 2 hours and 45 minutes, Jonathan cooked to death and Julio suffered his catastrophic injuries. Those are the two explanations for what happened in this case. And yeah, it would be nice to know how those kids got in that room. But luckily, I don't have to prove that to you. I just have to prove to you that the circumstances, and remember when we talked about circumstantial evidence and what that is, you don't have to see that it's raining outside to know that it's raining, okay? This did not have to happen, period. This did not have to happen because this defendant could have prevented it. He was absolutely their caregiver. Absolutely. There should be no reasonable doubt in your mind as to that fact. He tried to minimize it when he took the stand. Of course he did. Caregiver means a parent, adult household member, or other person responsible for a child's welfare. Adult household member. There's no requirement. It doesn't say only biological parent. And that makes sense, ladies and gentlemen, doesn't it? Because the consequences of it only being the biological parent are ludicrous. Because then step-parents could do anything that they wanted to kids and have no consequences. And that is insane. Neglect. What does that mean? The important parts of this definition, I think, are the words failure or omission to provide the child with supervision. Supervision that a prudent person would consider. Or a failure to make a reasonable effort to protect the child. And when you're thinking about neglect in this case, ladies and gentlemen, I think one of the most important factors that you should consider are the ages of these children. A 1-year-old and a 3-year-old. How long is it reasonable for you to let a 1-year-old child out of your sight? Not know where they are, not know what they're doing. How long is reasonable? And then compare it to how long we know it would have taken in this case. This was an absolute omission. And he tried to say that he checked on the kids. So he admits that he took on that responsibility of checking on the kids. However, we know that's not true. Because if he had checked on the kids, he would have known that the heater was plugged in. And he would have seen that they were getting hot, that they were uncomfortable, and that they were more likely than not crying. He would have seen that. So we know that's not true. And they knew, looking at the last paragraph talking about if it could reasonably be expected to result in serious physical or substantial risk of death to a child. They knew that heater was in that back room. They knew all that trash was in that back room. And he told the police, he told Detective Brock, he watched them go into that room to play. So they know all of these hazards are back there, yet they leave the children alone, unsupervised, a 1-year-old and a 3-year-old. And I think it's common sense that that is not reasonable. But there is no reason to leave a 1-year-old and a 3-year-old unsupervised, let alone in a room full of trash and a space heater. Culpable negligence is one of the elements. I know you're probably sick of hearing those words because you've heard them so much. But what's important about culpable negligence, what distinguishes it from simple negligence, is the recklessness and the disregard for human life. That, again, that this person, this defendant, should have known that leaving these children unsupervised for that period of time could result in serious bodily injury or death. And I think, again, it is common sense from the facts that we know, if he knew they were in that back room with that space heater, and he knew he had not checked on them, and he knew that Brittany Delgado had not checked on them for at least 45 minutes to 2 hours and 45 minutes, that there was a real possibility that they were not going to be okay. I will save the rest of my argument for you for when I get back up here in my rebuttal. Thank you.
Counsel?
Yes, sir, thank you. Good afternoon, everybody. I also want to thank you for your service during this time. We certainly appreciate you taking your time out of your schedule and coming here and being a jury. It's not just that we couldn't do it without you. It's because it lets the community, the people in town, make decisions as to criminal guilt or innocence, not the police, not the prosecutors, not even judges. Y'all make that decision. So we're happy to have you, and thanks for paying attention. Also, as mentioned, we get to break this up, or rather she gets to break up her argument into two parts. She gets to respond to me, so this is my only chance to respond to her. So let me go ahead and respond to her kind of in order of where she went, because I was taking notes as she was going along. In the excusable neglect jury instruction, she stated that you could go ahead and ignore that or don't even think about it. The judge read them to you. They're the law of this case. Please don't ignore any of them, specifically as to excusable homicide. When the killing is committed by accident and misfortune and doing any lawful act by lawful means with usual ordinary care and without any unlawful intent. If you're living in a house and you have a space heater and the kids tragically die because of the space heater, if you didn't do it on purpose, if you didn't know that they were putting themselves in danger, you could find that it was excusable homicide based on that. You don't have to. It's your decision. I'm just saying you shouldn't ignore it, as she suggested that you do. Count 2 in the jury instructions. She also directed you about Section B, failed to make a reasonable effort to protect JM from abuse, neglect, or exploitation by another person, saying that Brittany may have done it and he failed to protect the kids from Brittany. Well, there's nothing specifically in the evidence that Brittany was abusing these kids. We know the result, but we don't have any evidence showing that she was doing it, that she put the kids in the room. We don't know who put them in the room. And there's certainly no evidence that he knew she was doing anything wrong. In order for you to prevent someone from doing something wrong, you have to know that something bad is happening. If you don't know, you can't help. As to the evidence, I think we are in agreement to a large part of it. Yes, there were only 4 people in that trailer on that day, although there were other people there previously. That doesn't matter. The kids were brought out by them, and they were warm to the touch, and they were wet. But perhaps they were sweating, but we also heard testimony that they had been wet in the bathroom to try to cool them down once they realized that there was a problem with them. Specifically, my client told you that he did that. He went into the bathroom and was splashing water on Julio. While, as the defense attorney, I have to hold the state and you to your burden of them proving everything beyond a reasonable doubt, and you finding that they have really, there is no dispute that the child is dead. Jonathan is dead. I presented no opposing evidence. Nobody walked in with Jonathan. I don't want to be silly either. And it's true that JM suffered grievous injury. This was a huge tragedy. It should never have happened. I agree. Pedro agrees. He's sad that it happened. He didn't want it to happen.
Objection, facts not in evidence.
Correct. Move on.
Well, that was timely because the crying, as I objected to before, was also not in evidence. She was suggesting that the kids were crying out and that nobody did anything. There was no testimony at all from anybody that the kids were crying from being in the hot room. She mentioned about suspicious stuff, the doorknobs and stuff. Suspicion and speculation does not equal beyond the reasonable doubt. It's even in the definition. It can't be speculative. So why didn't they leave her cry? Well, maybe they were asleep and the heater warmed up the room slowly over time for 2 hours and 45 minutes, and they stayed asleep. Dr. Pena said that was possible. Maybe Brittany did lock them in there for whatever reason and accidentally turned the heater on, didn't know that the heater was on because it hadn't gotten hot enough yet. We don't know. That's a possibility, but it hasn't been proven that that's what happened. Maybe the kids locked themselves in. We saw that the lock was on the outside. I don't know if you've ever done this and had, with the lock on the outside and the door open, and as you grab it, you press it, and then close the door and get locked out, or locked in this case. It's possible that the kids did that to themselves, or really, Julio, Jonathan, was too young and too small to do that on his own. That's possible, but has that been proven? No, we don't know. And again, I have to disagree with her. I do think she has to prove exactly what happened beyond the reasonable doubt. She doesn't have to prove every single fact, but she has to prove the facts of the instructions that the judge read to you. She mentioned about neglect and was it reasonable? Leaving the kids in there unsupervised for 45 to 2 hours and 45 minutes. Well, that's a good question. What is reasonable? Is it reasonable to go to sleep and sleep overnight and not check on your kids every hour, every 2 hours, every 3 hours? Mind you, unless you hear something, the kids are crying or something happens that you think they need your help. Because if that's the case, then everybody's neglectful and abusing their children every day. I certainly slept overnight on my kids, and I still do. And that was the testimony in this case, that Pedro was asleep until about 11 o'clock. If it happened in 45 minutes to 2 hours and 45 minutes, she was awake from 7 o'clock in the morning. He didn't wake up till 11. That's 4 hours. That he didn't know what was going on, and that's when this could have happened. And why didn't he go check on them? Because he thought Brittany had checked on them. He asked her twice, what's up with the kids? Oh, they're playing. Oh, they're sleeping. So he thought they were fine. She's the mother. Is it unreasonable to expect that a mother who is present with her children should not be taking care of her children? If you, not even the father, have to supersede her supervision? No, it's reasonable to expect that the mother should be doing the supervision. All right, so that's my rebuttal. She gets a chance to rebut me one more time. This is my last shot at talking to you. Let's talk about the facts of the case and what's undisputed. They drove back from Panama City on December 9th, arrived very late, really on the 10th, very early in the morning, 2:30. That's undisputed. Nobody says anything other than that. They went to bed. Now, there's some question as to where they slept, but there's no question that they slept. And most importantly, there's no question that the children were placed in the room in the back, the hot room, as I've been calling it. They either slept on the couch with mom, or they slept on the couch with mom and Pedro, but they didn't sleep in the back room when they arrived. We also know that she woke up about 7 o'clock and that he woke up about 11 o'clock, not just because that's what they said, but because that's what their phone says. Because in this society these days, first thing most people do when they wake up is check their phone. Do I have any messages? Do I have any emails? What's going on in the world? It's common habit most of us do these days. And certainly when you have a gap in time between the night before when they arrived and the first activity being 6:47 for Brittany when she looked at Spotify, and about 11 o'clock, 10:57 if I'm remembering correctly, when he either made or received the phone call. We can't say if they were awake before that, but we know that they were awake at least at that time. We also know that children were found by Pedro in the hot room about 1 o'clock, and we know that because, as counsel told you, the 911 call came at about 1:13. So it may have been 1:10, 1:12, we're not sure exactly when, but it was right around 1 o'clock, just before that 911 call, that he found them. There's no dispute that he immediately was concerned, that he immediately tried to render aid, that he immediately called for Brittany, that he asked Brittany to call 911. That is not in dispute anywhere. It's also not in dispute that after they called 911, police officers and EMTs arrived almost instantly, a minute or two after the picture where you see them running out of the house holding the kids. That picture, the police were already on site. So they had just run out of the house and the first officer arrived. It's also not disputed that Pedro and Brittany gave conflicting statements to the police. Why did they do that? We don't know, but they did. There's no dispute that they did. What there also is no dispute over is that no one knows who turned the heater on, no one knows who put the kids in that room, no one knows how long they were in there, other than Dr. Bouchong's testimony based on his study of the room as to how long it would take. No one said that Pedro turned on the machine. No one said that he put the kids in the room. No one really knows whether he even knew they were there. He says he didn't. Well, I mentioned before that while we're not stipulating, it's undeniable and uncontroverted that YD died and that JM was injured. There was some evidence that Julio, the older one, had some existing developmental delays. Doesn't excuse anything, I'm just pointing that out. We also heard from several experts. The medical examiner, she did render an opinion of hypothermia, and that seemed to be based almost exclusively on the rectal temperature of 108 degrees taken by the EMTs before. That was her finding. That's not in dispute. It's also not in dispute Dr. Bouchong's testimony that it was somewhere between 45 minutes and 2 hours and 45 minutes. I also don't think that it's in dispute the testimony of my expert, Bo Biller, as to how the machine operates, and the very obvious statement that heaters are hot that he made, and that it's hard to know how hot they can get at any particular time, and the warnings may not be very precise on them. Regarding neglect again, I wanted to point out that the medical examiner found no proof of prior neglect, no broken bones, no bruises, nothing else to show that the kids were being neglected by this home. I also pointed out through some of the photographs, they did have food, they did have cleaning supplies. The house is a mess, but they did have food, they did have cleaning supplies. She mentioned that they didn't have any furniture in the room. I don't know if you saw it, but in the room there's a folded up travel crib. Again, that's not the best. It wasn't a pretty nice room, but it's not a crime to be poor. That's what they had. They had 2 playpens that they used as cribs and a mattress on the floor that they used to sleep on. That's just the truth. All right, going to the instructions. You want me to read the culpable negligence one again? I didn't think so. But those are the 2 most important words in those instructions. Maybe that's why he read it so many times. If there's no culpable negligence of my client, he's not guilty, period. If you look at all the different subsections and lesser included crimes, they all require some element of culpable negligence. It's kind of a Russian nesting dolls. You've got the bigger crime on the outside. Well, if you didn't prove one element, you take it down, you still got another level inside. Well, you didn't prove that. But when you get to the end, the nugget, the last doll, that's the culpable negligence. No culpable negligence, no crime. Excuse me, no crime committed by my client. There was a crime committed, and Brittany has pled to that crime. What possibly happened? Well, maybe Brittany did it. Maybe she put him in there. We don't know. Maybe Pedro did it. He says he didn't, but we don't know. Maybe the kids did it. Again, it's possible, because as she said, he's been known to open and close doors, and he's been known to turn on and turn off the machine. So it's possible that the kids did it. That's reasonable doubt. If you can say, well, maybe this happened, or maybe that happened, the rule says vacillate, and that's vacillation. Well, I'm not sure if this happened or that happened. Did Pedro do it? Did Brittany do it? Did the kids do it? I'm not sure. That's reasonable doubt. You should find them not guilty. If you believe that there was no culpable negligence, based on the definition that was read to you 17,000 times, you should find him not guilty, and you can go straight to, on count 1, not guilty, it's letter E. On count 2, it's D, and not check any other boxes. X, X, and your job is done. If that's what you believe, that there was no culpable negligence, I think that's what you should find. I think there's no evidence that he did anything wrong, or that they've proven a case beyond a reasonable doubt against my client. They've certainly proven that the kids were hurt. Huge tragedy. They never should have happened, but they didn't prove it against my client. And I think the most critical evidence are those telephone calls and the timing, along with Bouchon. If it took between 45 minutes and 2 hours and 45 minutes, and he was asleep during 4 of those hours, I don't see how you can find him guilty of anything. And that's the evidence before you today. Once again, I thank you for your time and your careful attention, and I hope you find my client not guilty as charged. Thanks.
May I proceed with my rebuttal, Judge?
Absolutely.
So I don't know if y'all noticed, but I did not ask Brittany Delgado any questions about the facts of what happened on December 10th, 2019. Not a single one. Mr. Iturralde is the one who asked questions of her about what happened on that day. And why did I not ask questions of her about what happened on that day? Because she, like this defendant, lied about what really happened on that day. They both lied multiple times. They both gave multiple inconsistent statements. And do you know why that is, ladies and gentlemen? Because they are protecting themselves. They're protecting themselves and no one else. They didn't care about these kids. That is evident from looking at those photos. No, it's not a crime to be poor, and nobody has ever alleged that. Nobody has ever said that. There's a difference between being poor and having your kids live in a house that looks like that. Not everybody who's poor's house looks like that. That's not an excuse for keeping a disgusting house with trash all over the floor, food everywhere, that these little kids could get into. That's not an excuse. If they had cleaning supplies in that house, don't know when the last time they used them was, I think that's pretty evident. This was a neglectful environment these children were living in, period. Those mattresses didn't have sheets on them. They're disgusting and dirty and sitting on the floor. There's no toys. There's nothing for children in that house other than garbage. And to say that because there were cleaning supplies and there technically was food out everywhere, that this wasn't a neglectful environment for those children is ludicrous. This is one of the most important parts of the jury instructions. It's entitled Weighing the Evidence. Remember in jury selection, I told you that the law tells you to use your common sense. Do not check your common sense at the door in this one, ladies and gentlemen, please. And these are all the factors that you should consider when you're weighing the evidence in the testimony. And I want to point some of these out to you because I think they specifically apply to this defendant more than anyone else in this case. Was the witness honest and straightforward in answering the attorney's questions? He could not answer a simple yes or no question with a yes or no. Every single question, and remember, they kind of tried to make a point that he has a hard time understanding English, but I don't know if you noticed, there were multiple times when he tried to answer both me and Mr. Iturralde when we were speaking in English to him, and he answered before the interpreter finished interpreting for him. He could not give a simple answer. He had to ramble and narrate and over-explain everything. Every single thing. A simple question. What time did you get up? Huge long explanation that didn't even answer the question. And why is that? Why do you think that is? Do you think that maybe because he's not telling the truth and that he's lost track of how many lies he's told and what he told the police, what he wrote in his statement, and what he decided to tell you here today? Did the witness have some interest in how the case should be decided? Who has the biggest interest in how this case should be decided? Him. He has every interest in how you decide this case. He is the only one. The law enforcement officers, they're just testifying about facts. He is the only one who really cares how you...
At me?
Let's be real, ladies and gentlemen. I'm not talking about Mr. Iturralde. Talking about the defendant. Who's on trial? Whose name's at the top of all these documents? Again, let's use our common sense. He, specifically him, since apparently we don't know who I'm talking about. Does the witness's testimony agree with the other testimony and other evidence in the case? Brittany Delgado and this defendant's testimony are the only ones. They do not agree with the other evidence in this case. Because they both said that the children were fine, that it all happened so fast, and we know that is not true. We know that's not true. And this defendant is the only witness, the only person who got to sit and listen to the testimony of every single person who got on that stand and watch all the evidence. He got to see my whole case before he decided if he was going to testify. He got to see all of that. He's the only person that got to do that before he took that stand. And he changed his story. His statement is in evidence. It's written in Spanish. But There's a certificate attached to his statement that has been translated from Spanish into English. And the English is typed on this third page. And I'm going to read it for you. It's in evidence. You can take it back with you. I woke up late today and took a shower. My wife prepared food. And we made some phone calls in regards to work that I completed yesterday because I had not gotten paid. The kids came into the room to play while the food was being prepared. And we called the insurance because they're billing us more than what is due. And I checked on the kids that were playing. I think the oldest connected the heater because it was on afterwards. I went to call the mom because they got sick and they were pale. All of this happened very quickly. Now, isn't that convenient? Because that's exactly the opposite of everything he said here today. But he wrote this on the day of the incident. Immediately after, on the hood of a law enforcement vehicle in front of the trailer. And he wants you to believe that he just wrote something down. No. He changed his story today because he got to sit and listen to everything that was said. So he could say, oh, well, you know, I didn't mean that. Because he realizes how bad that looks. That if that's true, which it's not, if that he really did write that and meant as he wrote, that he's lying. We know this did not happen fast. He told you, I lost count of all the inconsistent statements he gave. He said the room was warm, but not too much. Every other person besides him that went in that room said it was hot. And if that room was over 100 degrees, that's not hot. He said the first time he saw the kids was when he went and found them in the room. It's not what he told law enforcement. He told law enforcement he checked on them multiple times, that they were fine, they were playing, the heater was not plugged in. That he didn't see the kids, that he stayed in his room until he got up and showered. That Brittany Delgado, that he's never referred to her as his wife. And she's definitely not his girlfriend. Despite telling law enforcement that she was his wife and that they were in a relationship. But today, he wants you to believe that they weren't in a relationship because that minimizes his involvement. All he did today was minimize. If they're not in a relationship, then he thinks maybe they won't think I have a duty to these kids. Well, guess what? He still does, even if they weren't in a relationship. He doesn't have to be their biological dad. They don't have to be in a relationship. He still had a duty to protect these children. And Mr. Iturralde, asked, I think yesterday, how do you know if someone is lying? Ladies and gentlemen, I think it becomes pretty clear when the person has given numerous inconsistent statements, and the statements that they give on the day of their trial are so opposite to what they told the police back on the day of, that they have no emotion on the stand when talking about what happened to these children. That he's just trying to get out of it because he knows that he's guilty. Brittany Delgado knew she was guilty. She entered a plea. She knew it. She's like, yep, I'm their mom. I was neglectful, should have been supervising them. I'm done. I'm taking a plea. He tried to minimize everything so that you wouldn't come to the same conclusion about him. Mr. Iturralde made a mention of how, the circumstances are suspicious, how I had said that, and how we don't know the circumstances of how those kids got in that room. And that's true. And if you look at the elements again, he said, I think the state does have to prove that. No, I don't. Where in these elements, these three elements in count one, where does it say The state must prove beyond a reasonable doubt how those children got inside that room. It doesn't. It doesn't say that because that's not the law and that's not the case. Because again, if we could prove that this defendant or Brittany Delgado put them in that room intentionally, this would not be aggravated manslaughter of a child. This would be first-degree murder. We can't prove that because they both lied to the police and the kids can't communicate it to us. So we're stuck with what we've got, what we can prove. And frankly, it doesn't matter how they got in the room because in every single scenario, this defendant is culpably negligent. In every scenario, he neglected those kids. If he put them in that room, done deal. Obviously. If he put them in there, he knew what was in there and he didn't go back and check on them until they died. Well, the one died and one, obviously, Julio, suffered catastrophic injury. If Brittany Delgado put them in there, again, how long is it reasonable for you to think, gee, I wonder where the kids are, before you go check on them? And again, we don't know for a fact, for absolute fact, that the children were crying, but what did Dr. Pena tell you? Any child, which includes these children, because they are any child, would cry when they are uncomfortable, when they are hot, because that is how they signal that they are in distress. So if any child would do that, I think it's reasonable to, again, think these children would have been crying. And if the children locked themselves in the room, he's still responsible. Because they should not have been left alone in that room for that long without an adult checking on them. And he knew that he was supposed to check on them. That's why he told the police that. Mr. Iturralde says, well, he couldn't have known because he was asleep. Okay, let's assume that he's even telling the truth about that and that he didn't get up, he didn't wake up until 11. Okay, well, 11 o'clock, 2 hours and 45 minutes from 11 o'clock is 1:45, which is over a half hour after the 911 call was made. So we know they had to go into the room before that because that's the minimum amount of time that it would have taken. Remember, for the room to be at ambient temperature, I mean, if it 45 minutes, assuming the room was already 108 degrees, sure. Realistically, he saw those kids. She saw those kids. And then for a long time, neither one of them did. And neither one of them checked on them. And the why they didn't check on them, don't know. Don't care. Don't have to prove it. He was not asleep when this happened. This happened in the middle of the day. The 911 call was at 1:14 p.m. And if you go 45 minutes back from that, that's still after he said he had woken up. So either way, even if we assume he woke up at 11 when he says, the kids still would have had been in that room the entire time. He would have had to have seen them go in the room. Mr. Iturralde said Miss Delgado should be supervising them. Yes, absolutely. Just because she is guilty does not mean he is not guilty. It's not an either or. It's not only one of them can be guilty of this. Both of them can be equally guilty and equally as culpable. Or you can think she's more culpable because she's their biological mom. And that's fine. I don't necessarily disagree with that. But he can still be guilty. Just because she's more guilty doesn't make him not guilty. Mr. Iturralde said, well, even if, he did know they were in there, it's hard to know how hot these space heaters get, and these warnings aren't precise. This is where we put our common sense hats on and be so for real. How can you actually say that? Any reasonable adult knows that you should not leave a child alone with a space heater, especially one that you know can plug one in. These children suffered an unimaginable amount of suffering. Unimaginable. Dr. Pena told you the process that the body would go through when it's overheating. How you try to sweat, your body tries to do everything it can until it eventually just gives up because it just can't do it anymore. And Jonathan Delgado's little body tried everything it could to protect him on that day. Everything. His little body tried everything it could. And it doesn't matter. Because he couldn't get out of that room. Because this defendant left him in here to cook to death. His mom left him in there to cook to death. With his older brother, his 3-year-old brother Julio, sat in that room with him. And luckily he survived, and by the grace of God, the only reason he has any quality of life is because he got away from this defendant and his mom. And he's blessed with that angel of a foster mother who takes him to physical therapy and occupational therapy and speech therapy, who takes care of him, even though he is never going to have a normal life, ever again. And no child deserves that. These jury instructions tell you that failing to follow the law would be a miscarriage of justice. The miscarriage of justice in this case is letting this man walk free for what happened to those kids. This never should have happened, and he alone could have prevented it. He alone. Brittany Delgado should have too. And she's getting hers for what she did to those kids. Justice requires that you find him guilty as charged for what he did to those babies. Thank you.
In just a few moments, you'll be taken to the jury room by the bailiff. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict, and to bring the form back to the courtroom when you come. However, whoever the foreperson is, if you've reached a verdict, bring it back like this. Don't bring it back like this, okay? During deliberations, jurors must communicate about the case only with one another and only when all the jurors are present in the jury room. If a juror goes to the restroom, the deliberation should stop until the juror returns. You are not to communicate with any person outside the jury about this case. Until you have reached the verdict, you must not talk about the case in person or through telephone, writing, electronic communications, such as email or any other means. Do not contact anyone to assist you during deliberations. These communications rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the bailiff. Now, many of you have cell phones, tablets, laptops, or other electronic devices. The rules do not allow you to bring your phones or those types of electronic devices into the jury room. Kindly leave those devices on your seats, where they will be guarded by the bailiff while you deliberate. If you need to communicate with me, send a note through the bailiff. If you have voted, do not disclose the actual vote in the note. If you have a question, I will talk to the attorneys before I answer, so it may take some time. Many of you may continue your deliberations while you wait for my answer. I will answer any question if I can in writing or orally here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will be helpful to you in your deliberations. These exhibits will be sent into the jury room with you when you begin deliberations. In closing, let me remind you that it is important that you follow the law as spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we've lived by the Constitution and the law. No one of us has a right to violate rules we all share. Counsel, did I give the instructions I previously said I would give?
Yes, sir.
Yes, Your Honor.
You may now retire to consider your verdict. Yeah, but Miss Harrison, if you'll wait here a moment, okay? You need this?
Well, yeah, you mentioned that. Yeah. Yeah, but that's positive.
Do you have anything in the jury room? Huh? Tell the bailiff what it is and he'll get it for you.
Whatever the judge wants is fine, but yeah, I agree. You need to take that out.
Ms. Harrison, I always want to talk to you're the alternate. I always like to talk to the alternate because I think you have the most thankless job. Because number one, you show up on a Monday in that palatial jury assembly room downstairs. Then you sit through voir dire, you select a jury, you're selected, you don't know that you're the alternate. You sit through the trial, and then you don't get a chance to vote. That's what I think is a thankless job. But it's an important job, because if something were to happen to one of the other jurors, family emergency, sickness, then you would be in a position to step in and take their place. I want to thank you for your service. Now, you're more than welcome to stay and see what the jury's going to do, but you'll have to sit out in the audience. If you want to go home, you're free to go. If you want to find out what the verdict was, you can call Judge.
Miss Tracy will get it on the
Who?
Miss Tracy, the Madam Clerk.
Oh, just call the clerk's office, and they'll tell you.
All right.
And I want to thank you once again.
You're welcome.
You're discharged.
Thank you.
Now, count. They did take their notes with them, didn't they?
Yes, yes, sir.
Okay. Hmm?
The only thing, Judge, is we did make a mistake on the verdict form, so before the verdict form goes back to the jury, I'm gonna reprint the last page. I showed it to Mr. Richaralde. He agrees. I didn't catch it on the first 3 times I read it. It was
Let me see the verdict form.
it's the lesser included crime, so letter B under count 2. It had aggravated child neglect, which is the crime charged. So it should just say the lesser included offense of neglect of a child.
And without cause of great bodily harm, because that's the aggravated.
You're both in agreement.
Yes. So it should state the defendant is guilty of the lesser included offense of neglect of a child as to JM.
Yes.
Okay, we'll make that change. They can start their deliberations, and then we'll send the revised. We won't give them this verdict form, we'll just send you a new one.
And I'm
back.
also going to remove the severe injury interrogatory because obviously that would make it child neglect causing great bodily harm.
Oh, yes.
So those are the 2 changes. The only other thing, as far as evidence, I was just looking at the table, and I know Madam Clerk is checking right now. All my evidence is over there. The only thing that I noticed was the space heater manual is on the table. I don't recall that ever being entered into evidence. I know questions were asked about it, but I did not write that it was ever entered. I don't believe that it was.
Hang on.
You say this one or both of them?
Just this one. Because this one doesn't make it GBH.
Actually, the space heater manual was defendant's exhibit 2.
Right, but I think he only, but it was defense exhibit 2 for ID. I don't ever remember him. He asked Mr. Biller about it, but he never entered it. He entered the photos, which were defense 1, but he never entered defense 2, which is the manual. So I would object to that going back to the jury room.
I thought I did.
Well, I have marked that he did.
I would ask for the clerk or the court reporter to check, because I know the clerk checks every time something is entered into evidence, the clerk has to keep track of it. So
I have it as not entered, but I will ask for a double check on the court reporter just to make sure.
Now, if my memory serves me, I believe the testimony was the question from youth counsel was, did you find a manual? He says, I found a manual. Didn't say where he found it, how he found it.
right, he did ask him questions about the manual.
Oh, yeah.
But he didn't enter it into evidence as an exhibit. So I don't want it going back to the jury because it was never entered.
For whatever it's worth, I thought I did. I'd asked that the defense be reopened and that I be allowed to reintroduce
And I
it now.
I don't reopen a case once the jury's out. And that was a different court reporter too. Was it not? No, it wasn't.
No, it was her because it was this morning.
Okay.
Would you like for the court reporter to check, Judge? Madam
If
Court
you
Reporter?
could, please.
Would you be able to check that? We'll stop talking so you can stop writing.
We need to go off the record before she can check.
Overlooking the manual.
Yes, it would be defense exhibit 2, whether it was entered.
And it was the first witness, Bo Biller. We've been right after openings, or shortly thereafter. My opening.
Están buscando si yo moví en la audiencia. Yo pensé que lo dice, pero dice que no. Y está mirando a ver si lo encuentra. En sí, no importa mucho porque el testimonio pone todas las seguridades. Pero quisiera que antes lo fuera. Y ese cambio hay que hacerlo antes de darle un ratito cuando están las nuevas, le van a dar esto en su audiencia atrás y luego pueden tener cuánto tiempo yo quiero. We're going to accept you, we're going to be taken back, and okay. Cuando terminemos, que te van a dar abajo.
Okay, there was just, you're showing me what's been marked as Exhibit 2. Ask you to see if you can identify that. Yes. More questioning, never submitted for entry of evidence.
I'm sorry, I missed that.
Oh, I'm sorry. No, it wasn't alternate evidence.
No?
I showed him one question. And your
Okay.
question was followed.
It doesn't go back.
So there's my 3.850 right there, Judge.
Huh?
Back on the record?
Yes, yes.
Okay.
Whatever.
So just so we're clear, we're back on the record now. I believe Madam Court Reporter was able to look. Defense Exhibit 2 was not entered into evidence, so it will not be going back with the jury.
It was offered for identification.
Yes, sir. And my assistant is currently printing the corrected final page of the verdict form and bringing it down now, so that should be here any
Okay. All right.
Are we in recess, sir?
Absolutely, until we get the verdict form.
Yes, sir.
And then, well, we need you to look at it again.
Yes, sir.
She's on her way right now.
All right, well, hang in here a minute.
I'm here.
You have my
Okay.
phone number, right?
Yes, ma'am.
850-264. Thank you, ma'am.
Did you all want to go through this to double check?
I trust you. Did you take out the manual?
I did, manual.
That's the only concern. That's
Manual of that will be on my desk.
Did you want to go through the evidence? She asked.
No,
I mean, yeah.
I trust her.
Yeah. Para abajo, no tiran para adelante, porque mantienen abajo. Cuando ellos llegan a una decisión, llaman a todo el mundo.
Just one interpreter can be excused since all we're waiting for is the verdict now, and I'm missing.
The verdict form.
Or do you want me to wait for the form and then?
Yes.
I have the
Oh, sorry.
last page. Would Your Honor like to check it?
Okay. This is for the second page?
It's just the last page.
Okay. All right, well. Okay, just the last page. Now, as far as excusing the interpreters, who's here for
I'll stay, Your Honor.
Mr. Alvarado?
Yes, I'll stay here.
But you were here for, I can't, she can be excused, right?
Yes,
Yeah.
yes. Usually when I work with Tanya would stay, and then I would leave since I live in Madison, and I'm an hour away, and she was a staff interpreter, staff employee, so she would stay. And I'm a contractor, so.
Well, Tanya's my boss, so, you know.
I will let her know you said that.
She knows it.
She knows this.
Yeah, yeah,
We miss her though.
yeah. Okay,
Thank you so much, Your Honor.
thank you.
Clerk?
Now, we'll wait to hear from the jury.
Yes, sir. I am going to stay about, I don't know if I can stay in the courtroom or not. My office is too far away to go there and come back at short notice.
You're welcome to stay.
Thank you, Jim. You too. Thank you for your help.
Just sitting. We're leaving.
Oh, yes.
What did you think about the closing arguments?
El jurado ha hecho una decisión. Estamos esperando que venga el juez. Y estamos esperando a ti. You're going to keep it quiet?
All rise. Court is back in session.
Be seated, please. My understanding, the jury's reached a verdict. Are we ready for the jury?
One question, sir.
Yes.
My client is shackled. Can we remove the shackles while in the presence of the jury?
I don't think they can see the shackles.
Well, if he rises.
We will not rise when the jury comes in on this time.
Okay? No.
Not my preference, but I understand. Let's get it done.
All right, let's bring them on.
Bailiff.
Esto es, no te pares.
I didn't see who was holding the verdict. Okay. Is it Berto? Miss Berto? Excuse me?
It's Berta.
Okay. I just can't read that writing. Since you have the verdict form, I assume you're the foreperson.
Yes.
So jury reached a verdict now. If you would, please hand the verdict form to the bailiff. Thank you. Madam Clerk, if you would, please publish the verdict.
In the Circuit Court of the Second Judicial Circuit in and for Leon County, Florida, the State of Florida versus Pedro Ramirez Alvarado, case number 2019 CF 4209B, verdict. Count 1, aggravated manslaughter of a child as to YD. We, the jury, find as follows as to count 1 of the information. The defendant is guilty as charged of aggravated manslaughter of a child as to YD. If you find the defendant guilty of aggravated manslaughter of a child, he must then answer the following questions. Did the state prove beyond a reasonable doubt that the defendant was a caregiver for YD? Yes. Did the state prove beyond a reasonable doubt that YD was under the age of 18? Yes. Did the state prove beyond a reasonable doubt that the death of YD was the result of the defendant's culpable negligence? Yes. Count 2, aggravated child neglect causing great bodily harm as to JM. We, the jury, find as follows as to count 2 of the information. The defendant is guilty as charged of aggravated child neglect causing great bodily harm as to J.M. Did the state prove beyond a reasonable doubt that J.M. suffered severe physical injury as a direct result of the crime? Yes. Did the state prove beyond a reasonable doubt that J.M. suffered moderate physical injury as a direct result of the crime? Yes. So say we all this 8th day of May, 2024.
Would you like the jury polled?
Yes, please.
Ms. Bordeaux? Is this your verdict? Ms. Avello Burnham, is this your verdict?
Yes.
Ms. Newell, is this your verdict?
Yes, sir.
Mr. Kagi, is this your verdict?
Yes, sir.
Ms. Pepper, is this your verdict?
Yes.
And Ms. Van Hoff, is this your verdict?
Yes, sir.
Members of the jury, I want to thank you, excuse me, for your time and attention to this case. We've long recognized that the jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. While you're at liberty to speak with anyone about the jury's work, you're also at liberty to refuse to speak to anyone. Only by court order can you be required to reveal what goes on in the jury room. I want to thank you once again for your time and consideration of this case, and you're hereby discharged with my thanks. Y'all have a good evening and a good rest of the week. We're going to need a PSI in this case?
Yes, sir.
They take how long?
Usually about 30 days, Judge.
You want to set a tentative sentencing date?
If we want to right now, just, I mean, we can, or we could set it for a case management in the meantime. I'm fine with either one.
Well,
If I may,
yes.
he has pending immigration proceedings. He has a case set in Miami. He was brought up from Chrome for the trial. He has one set for May 16th. He'd like to participate in that if he could, otherwise it'll be postponed.
May 16th, we couldn't do it anyway.
Before then, no, but I don't know how the court feels about giving him the opportunity to go down, obviously transported, and then come back up, and that would change perhaps the court's date setting.
Well, why don't we do this? Let's just order the PSI today. The jury having found Mr. Alvarado guilty as charged of both counts, I'm going to remand him. I have no problem if he is transported down to Miami and then brought back after the hearing, but I don't want him languishing down there. I want him back up here. Fair enough?
Yes, sir, understood.
I'm guessing that's probably going to have to be some sort of motion and order that's filed, because I don't think the sheriff's office, I could be wrong, I don't think the sheriff's office is just going to transport him to Miami for no reason, so.
No, I believe you're
Yeah.
going to have to file a motion.
So,
You can put in the motion that we've discussed it in court, and that in the order, I'll sign the order. I don't want to set a case management because they are using up all their senior judge days, you know?
We can just put it on my business day with Judge Everett, just as like a status, so it doesn't fall off.
Okay.
So my next date is next week. So would Your Honor just like me to set it next week, or would you like me to set it on my business day in June?
Just set it on your business day in June.
Okay, Madam Clerk, can we set it? Do you have the ability to do that?
I do, yes.
On June 12th is my business day.
June 12th?
Yes, sir.
Okay.
And I believe because Mr. Iturralde is private counsel, I think that's Judge Everett's 2:30 docket? Okay, 2:30.
And that will be in front of Judge Wheeler?
Judge Everett.
Judge Everett.
If we get the PSI back either before then or at any point, should we get with Tanya to schedule the sentencing with
Absolutely.
you? Okay.
She controls my courtroom life.
I figured I just wanted to make sure I knew the right person to get a hold of.
There you go.
Okay, I appreciate it, Judge. Thank you. Are we in recess?
Hmm?
Are we in recess?
Well, I'm going to adjudicate him right now.
Oh, okay. Well,
The jury having found Mr. Alvarado guilty of aggravated manslaughter of a child and aggravated neglect causing great bodily harm, I now adjudicate him guilty of both of those counts. We ordered the PSI, and we'll look to June 12th at 2:30. If the PSI comes in, I'm sure that Judge Everett will make some time for me to come in, and we can handle the sentencing at that time. Okay?
Yes, sir.
yes, sir.
Good luck to you, sir.
Thank you, Your Honor.
Now we're adjourned.
Thanks for watching. What did you think about the result in this case? Until next time, Stephanie the Sleuth and Mentor Lawyer. Thanks for watching Deep Dive True Crime. Thanks for watching Criminal Breakdown. Thanks for watching Mentor Lawyer Justice Network.